I'd like to do now is to start going through the ordinance. Council members, if you have questions, please let me know as we're going through here. I guess my first one, we're going to go through lines 1 through 10 to begin with, and I think it was answered just a minute ago by Mr. Dobson about the fact that there are things that are outlined in this ordinance that are currently have not said that they are permitted under state law. So my question, Mr. Smithka, is, does this become confusing to someone who's reading the ordinance with the fact that they're assuming that they're going to be able to get licenses for these immediately? And does it give them, because we all know how convoluted this has been right along, does there need to be some provision in the beginning part of this listing what those are, stating that currently they are not, these licenses will not be available for those particular entities until establishments until the state makes changes?
Well, it provides for a license right now, no matter what the state does. That's the way it's drafted, that's the way it's defined in each of them. So there is a license that is required for each of these facilities. The definition, as we go through it, you'll see that, for example, medical marijuana processor facility means a commercial entity located in the city that has a license issued by the state to the extent one's required, and it isn't required, and has a license from the city. So we are licensing all 4 of these areas. Now, to the extent that the state then licenses it, they have to get a state license.
Okay, so what you're saying is these entities can, if licensed, can immediately start doing what is in this ordinance. So I can put together a commercial grow facility, and I think it talks in here about H or I industrial, and I can start that process. Is that what you're saying?
What we're saying is that there's someone who is either operating one right now or intends to, they have to file an application with the commission, and they could obtain a license, yes.
And they could start doing that business?
They would have to receive a license first.
Yeah, but I mean after getting the
yes.
license, they can start doing it.
As long as they don't violate other federal laws.
Yes, go ahead.
And that's where I struggle with this, and I really don't want to. You know, this committee has spent a lot of time looking at a lot of different language, and none of that is before us today. And so what I thought we were going to be looking at was something that, and I spoke to Mr. Dotson earlier, because this language, this anticipatory language, does permeate this document, and it, as Councilmember Wood stated, it is convoluted. It's difficult to follow. And I'm just worried about, and I had a conversation with somebody earlier, and I thought they hit the nail on the head. Is this enforceable today? Is this one of my struggles when we talk about a commercial grow? What does a commercial grow, in terms of the MMA? I don't think it's permissible. But what does a commercial grow look like at this point that comports with state law? I don't understand why we even issue a license. Does that make sense?
It's defined in the grower facility. It's on page 4. It's a cultivation facility, one that's located in the city that is licensed by the state to the extent one is required, that cultivates, dries, trims, or cures packaged marijuana in accordance with state law. And so yes, those issues are anticipatory for the change. And again, the reason being that these are discussions that are occurring at the state. These may end up in the state law. And rather than have to go back and change our ordinance, they automatically fill in. Because it's covered, it doesn't necessarily mean that they will be receiving a license. They have to be vetted through the commission.
Okay, maybe, just a second. Maybe a better way to ask this then is that if the commission were vetting this and believed that the state was not allowing this, then they wouldn't get a license.
Right, correct.
Okay. So that's the way to answer this then, is just because it's here and you apply for it, if the commission deems based on court decisions and different things that are happening during this process, they could determine that we're not going to issue the certificate for the license.
Absolutely.
Okay, Mr. Dobson?
Yeah, can I get
Yeah? Watch
Prosecuting Attorney Whitmer made reference to this earlier. The act as written is unclear. It allows for a caregiver to grow. Is that caregiver a grower? Well, I suppose you could describe that caregiver as a grower. This allows for a caregiver to grow under the term described as grower, but only in conformance with the MMMA. Same with dispensaries, same with processors, same with those that might be compliance centers. Everything is contingent, regardless of the label that you place on the entity, with a requirement that you be consistent with the MMA. The MMMA is silent on how this dispensing is supposed to take place. It doesn't refer to dispensaries. It doesn't refer to growers. It just refers to growing. It doesn't refer to compliance offices. It doesn't refer at all to anything that might suggest that we're going to test these drugs, or excuse me, medical marijuana. So I think we're getting bogged down into form over substance. There's nothing in here, and it's made quite clear repeatedly, if you go through the different entities that are allowed or that are required, the city's going to require licensing for, that you have to conduct yourself consistent with state law as it exists, as it may be determined down the road. And once again, grower just refers to someone who grows. Currently, the MMMA allows for growing to occur. It just does not identify growers or the growing as growers. Certainly to the extent that any activity is inconsistent with the MMMA, the commission will deny the license application. But this is an imperative. This is not something that is optional. Every entity that is issued a license by the city has to comport with not only the city's laws, but also the state laws.
And I understand what you're saying, but I think part of what you're missing from our perspective is a couple of things. One, we've repeatedly heard here that a caregiver that's growing their 72 plants does not need a permit from the city. What I'm hearing you say is growing, any growing, they're going to be required to have this. Is that what is being said?
A commercial grower.
Okay, and what is the definition of a commercial grower? Is it more than 72 plants?
No, that would be inconsistent with the MMA.
Okay. Yeah. You had a question? Okay. Then I guess my next question. No, I'll save that one. All right. I think we got your definition, so, all right. Pardon? Patricia?
Thank you. I guess I'm trying to get some clarity too. I mean, what we have now existing in the city are these establishments where you have these caregivers on site who may or may not, you know, be cultivating these 72 plants or whatever. And how I'm seeing this is an attempt to kind of place those locations in some sort of regulatory structure or framework. Is that, am I kind of off base with that? Because I'm understanding again, because of recent court action, we, you know, if and I want to do, a qualifying patient is growing in their home, that's not something we can regulate. Or a primary caregiver, we can't regulate that. And so, you know, we're trying to address what we can address. We have these locations throughout the city of Lansing where we know there are congregations of plants. So I get what they're doing, and I get why you have to have this regulatory structure that may seem out of the norm from the MMA. It is kind of wonky, though. I agree.
I think, let me try to outline something here. Just
Okay.
forget about all these other areas, the growing, the cultivation. Let's just take the centers, all right? This requires an application for a license for a center that goes through the commission. They have to meet the criteria. They either get a license or they don't get a license. If they don't get a license, whatever's out there now has to stop,
Okay,
period. And it's a public nuisance if it doesn't.
Okay.
Let's not get into the other ones right now. Just take that main provisioning center. That's the simple structure. And so, now, what are these other things?
Yeah.
These are activities that are going on and have been discussed at the state level that may be regulated. And we put them into the ordinance so that when they become regulated or becomes clarified in the state, then we have, it's self-executing under our ordinance, and they have to have a license.
okay.
That's what that's what it's all about. If you just look at the provisioning center, though, that's the core of it.
All right. Okay, we've gone through lines 1 through 10. Are there any other questions? Do lines 1 through 10.